Okay, now we've got 30-year former federal prosecutor and host of Justice Matters on YouTube, Glenn Kirshner. Glenn, thank you for coming back on.
Great to be with you, Brian.
Let's start with the January 6th committee today. Obviously, a lot of major news coming out of that last hearing. And the biggest piece is that they voted to issue a subpoena to Trump. What are Trump's options here?
His options are to defy the subpoena, which I fully expect he will do. And then the ball is in the J6 committee's court. They can do a couple of things. One, they can vote to hold him in contempt and make a criminal referral to the Department of Justice for a contempt of Congress charge. We know they've done that before, and it's met with mixed results, right? They did that for Steve Bannon and Peter Navarro, both of whom were indicted by the Department of Justice. They did it for Mark Meadows and Dan Scavino, neither of whom were indicted by the Department of Justice, which I find a little bit offensive because the co-equal branch of government, Congress, was a victim of the crime, the contempt, and yet for whatever reason, DOJ sort of turned up its nose, at least thus far, at the prospect of charging those other two men for committing precisely the same crime that Bannon and Navarro committed. So they can do that, though I suspect that is less likely than their second option, which is to pursue civil contempt in court. What that looks like is they will file suit in court to enforce their subpoena. And that will put Donald Trump in a position where he'll have to go to court. He will have to respond. In my opinion, he will absolutely lose the court battle, and then a judge will order him to testify. If he defies the judge's order to testify, as opposed to just defying the subpoena to testify, a judge can actually order that he be detained until he purge the contempt and appear and testifies. Now, what will he do if he is ordered to testify? We already know, Brian, we will now all be back on the hamster wheel of endless appeals. Although at least the courts seem to be expediting the court hearings and they're not letting Donald Trump run out the clock. And of course, the Supreme Court just rejected his attempt to pull the court into the Mar-a-Lago documents debacle. So right now, I think at the moment, things are looking up a little bit on the justice front.
Can you just expand on why the Justice Department would choose to indict someone like Steve Bannon and yet refuse to indict someone like Mark Meadows?
One of three reasons. Either they believe Mark Meadows is so close to the president, a former chief of staff, that they have some sort of privilege concerns. They don't want to go that high up on the food chain and charge somebody with contempt when that person says, look, I actually have some viable privileges that I could raise. That may be one reason. A second reason is they may be looking to roll him into a far larger and more significant indictment, like a conspiracy to defraud or commit offenses against the United States. That's what I would be doing if I were a prosecutor. They don't want to piecemeal a criminal prosecution against a guy like Mark Meadows, so they wouldn't want to jump out and just indict him on what is a misdemeanor charge of contempt of Congress. They want to wait and roll it into a larger conspiracy indictment. And of course, the third possibility is that Mark Meadows is cooperating. Because if he's cooperating, there is no need to bring an early charge against him. So those are the three possibilities. I don't know. I think it's a 33 1/3 proposition for each.
Now, to what degree can Trump delay? Because like how many avenues does he have to be able to delay this thing?
It depends on how Congress chooses to try to enforce the subpoena. But let's assume they go the civil enforcement route, which I think with a former president is most likely. The courts can set an expedited briefing and argument schedule. So they can certainly resolve it in the trial court pretty promptly. And then the appellate court can similarly, just like the 11th Circuit just did, set an expedited schedule. They can resolve it promptly. And now we know that the Supreme Court can even resolve a request for review within about a week. So there's a very real prospect, Brian, that all of this could be resolved in about 60 days and Trump would have nowhere left to go. But I can tell you precisely where he will go. He will walk into the J6 committee hearing room, raise his right hand, be sworn in, answer the question, state your name, and plead the fifth to every other question after that, because he already has a track record of doing that in New York in Tish James' civil deposition, where he pled the fifth 440 times. And there was less riding on that than there is riding on him testifying before the J6 committee, because anything he says not only can incriminate him, but will incriminate him, because the J6 committee would package up that transcript and deliver it to the Department of Justice, I believe, in conjunction with a criminal referral.
Okay, so that was actually my next question in terms of Trump does eventually end up in that deposition room. He's absolutely going to plead the fifth in every question other than his name. That then could be used as evidence against him if he's eventually charged by the DOJ and that goes to trial, correct?
No. See, here's the difference between pleading the fifth in a civil setting, like in the Tish James civil suit,
versus a criminal setting.
Versus a criminal setting. But it's a great question, because it's an interesting hybrid, right? Because the J6 committee is not a criminal proceeding. But if we were ever to try to use somebody's invocation of their Fifth Amendment right against self-incrimination at trial in a criminal setting, that would be reversible error, because it would be kind of pointless to say you have a constitutional right to invoke the fifth and not incriminate yourself. But if you do, we're going to use it against you by introducing it against you at a criminal trial. That's verboten.
Now, Trump released a statement in response to the subpoena that was pretty much exactly what we thought it would be. It was a rambling diatribe pointing to his own victimhood. You'd mentioned online that statement was incriminating. Can you expand on that?
I sure can. So I brought a prop with me, and maybe I'm the carrot top of legal analysts, but let me show you what I would do with this statement issued by Donald Trump, which opens with the line, all caps, "The presidential election of 2020 was rigged and stolen." We all know, any critical thinker knows, any honest person knows, that is a lie. And it's a lie that is designed to continue to deceive the American people. It is a lie that is further deeply incriminating evidence and proof of Donald Trump's conspiracy to commit offenses against or defraud the United States. Brian, this is what I would do with this statement. I would take one of my government exhibit stickers, which I use tens of thousands of over the years. I would slap it on this statement, and I would introduce it as Government Exhibit 1 as deeply and sharply incriminating evidence against Donald Trump. Why? Because he attaches a chart at the end, sort of including all of the allegations of election fraud in the battleground states that are lies. They've been disproven. It's propaganda. And his own administration officials and agencies told him the election wasn't rigged or stolen. His own family and advisors told him the election wasn't rigged and wasn't stolen. But he continues to con. And what that is it is evidence of his continued conspiracy to try to defraud or commit offenses against the United States.
I think one of the most effective parts of this latest committee hearing was the fact that we would have testimony from these people, from the DOJ, for example, who said, yeah, Trump would come in and spout off these bullshit talking points about suitcases. And we explained to him, Mr. President, we don't know what the hell you're talking about. There's no conspiracy about suitcases. And then they showed how 10 days later, he'd be up on that stage at the Ellipse, spouting off the exact same now debunked talking point about suitcases, showing that even though he knew these talking points were debunked, he continued to introduce them and use them to pepper his supporters into doing his bidding, which was to eventually go and ransack the U.S. Capitol. So the fact that he's doing it right here in this exact same scenario in court, after we already have the proof in public that he's been told that these talking points were false, is like you said, proof that he's just continuing to promote the exact same lies that got him into this mess in the first place.
Yeah, and I was in the committee room yesterday for the hearing, and I have to admit, I've got prosecutorial goosebumps. I mean, the evidence was so compelling. And they presented such a powerful chronological narrative detailing, documenting, cataloging all of the evidence in support of Donald Trump's crimes that, all that is left, and we've said this before, is to just prod into wakefulness, that great beast, the law, the criminal law, and charge the man, because the beauty of bringing a criminal case when supported by the evidence is all of his, what we call interlocutory appeals, this piecemeal appealing of every issue decided by a court. It goes away. It evaporates. It's not available to somebody who is being criminally prosecuted. The only appeal that he can take after he's indicted is once he's tried, once he's convicted, once he's sentenced, then he gets to appeal. But in this endless civil litigation, he will continue to piecemeal file these bogus appeals to run out the clock, to weaponize the delay built in the civil litigation system, none of which he can do once he is criminally indicted. So we've got to get off the dime. We've got to bring the charges. We have to at least start to bring our long national nightmare to a close.
So we're on very much the same wavelength here, because my next question is exactly that. You know, these January 6 hearings are finally coming to an end. This was billed as the final hearing. Congress doesn't have the ability to charge anyone. This was always a fact-finding mission, but their investigation obviously can inform the DOJ for their concurrent investigation. With that said, it's been 1.5 years. What's the expected timeline for an indictment against Trump if we're going to see one?
Impossible to predict. I'm happy to try to predict, and I will likely be wrong.
Maybe just a spectrum here, because we're 1.5 years in. I imagine that's already longer than some indictments can have happened already. So what's I guess the spectrum of something that we should expect for something like this, even notwithstanding the fact that this still is unprecedented given who Trump is?
I think first of all, the classified documents crimes that have Trump dead to rights on those crimes. I think that's an easier case to more quickly indict. So it could be right after the midterms, because I still believe Merrick Garland is going to be a little bit too much of an institutionalist, and he's going to wait until after the midterms. We could see classified documents indictments drop first and insurrection indictments drop thereafter. If I had to guess, Brian, I think Donald Trump ends up being criminally indicted by the first of the year.
Now, the Republicans have been trying to deflect attention away from Trump for the better part of a year by claiming that actually it was Nancy Pelosi who's to blame in all of the events of January 6th because she purportedly never called for backup. This most recent January 6th committee hearing proved with video evidence that, in fact, Pelosi worked relentlessly to call in for backup, called basically everyone, governors, mayors. She called Trump cabinet secretaries. And the only person who was absent from those efforts to get help from these insurrectionists on January 6th was Trump. What was your response to that revelation?
So first of all, that video footage that was new to all of us, I believe, of Nancy Pelosi, Chuck Schumer, and others while the Capitol was under siege, making these desperate calls to Virginia Governor Northam, Maryland Governor Hogan, the mayor of D.C., the Secretary of Defense. And this is what I found so compelling and so chilling. You heard them say, if the White House was under siege, if the Pentagon was under siege, you would send reinforcements to protect the people, send them to the Capitol. And Donald Trump still refused to send the forces necessary to protect the people in the Capitol and to repel the attack that, of course, he launched. I found that just so disturbing and chilling and incriminating. So Donald Trump can make all the BS claims he wants that this was Nancy Pelosi's fault. There's no evidence to support that, just as there is no evidence to support any of the nonsense in this self-incriminating letter he just threw into the public square. And let me add, anybody who helped him draft this letter should be looked at as a criminal co-conspirator.
What would you say to Kevin McCarthy, who's basically said he's gonna turn this January 6th committee hearing into a hearing against Nancy Pelosi if the Republicans take control? What would you say to him, given these revelations that, in fact, the only reason that a lot of these Republicans are alive right now is because Pelosi and Schumer and Democrats took the steps necessary to make sure that all of the members of Congress of both parties were safe?
You know, I don't think I would say anything to him, because you can't reason with a painted rock. And that's what he's shown himself to be. No better, no smarter than a painted rock. So really the only thing that we can do is get out and vote and not let the Republicans take control. Because here's one thing that I do believe. I believe the Republicans, if they take control of the House in particular, will do everything they can to continue to destroy the institutions of government. They will go scorched earth. They will carpet bomb the Department of Justice with subpoenas. And then, Brian, you know what they're going to do? They're going to find reasons to say that the people on whom we served these subpoenas didn't fully comply. Send the sergeant at arms of the House out to lock them up by using our inherent power of contempt, which is a lawful thing that the Dems have been unwilling to use. So Kevin McCarthy, let's hope he never takes, the reins of power, because if so, I think we will find ourselves in an even darker place than we are already.
So I want to switch bases to just one other topic that we heard about this past week, and that was the defamation case, the E. Jean Carroll defamation case against Trump. A judge is allowing that deposition to move forward with Trump on October 19th. Do you imagine that he'll plead the fifth in that deposition, and how would that factor into a judgment on that case?
Yeah, I suspect he will, because he did in the loosely analogous civil proceedings that Tish James brought against Trump and his family members in the organization. If he doesn't, it will be a whole bunch of I don't recall. But if he does invoke the fifth, then in a civil setting, in a civil case, which is what E. Jean Carroll brought, a defamation case, because he did use the power and the pulpit of the presidency to lie and bully a victim that he sexually assaulted. How horrific is that? And that's why I wish the Department of Justice never took up this cause on his behalf. But if he pleads the fifth, that can be used against him in the civil litigation. Pleading the fifth in the context of a civil case is the death knell to any hope you might otherwise have of winning that civil case, because the jury, when the case goes to trial, is instructed by the judge. This defendant invoked his Fifth Amendment right against self-incrimination when he was asked questions that were relevant to the allegations that have been made against him. Ladies and gentlemen of the jury, you can use that. You can hold it against him. You can draw negative inferences from it, that if he had answered the questions, if he hadn't invoked the fifth, the answers would have hurt his cause. That is devastating to a civil litigant.
Glenn, let's finish with this. You mentioned that you were in the hearing room for the January 6th committee hearing, that final hearing. What was the most impactful point in that hearing for you?
Oh, here's what I really appreciated. The members of the committee are legislators, right? They're not prosecutors. And yet, almost to a person, they were using the language of prosecutors. They were saying over and over again, the evidence shows that Donald Trump, in a premeditated way, knew that he was going to claim he won the election even before the votes were tallied. In a premeditated way, he was intending to say the election was fraudulent, that it was rigged, well before the election was ever conducted. And you could just feel the way they were building toward what I believe will ultimately be a criminal referral of Donald Trump to the Department of Justice, which may impact the Department of Justice thinking, and it may not. It probably won't. DOJ will say, thank you very much, co-equal branch of government, for your opinion. We will continue to do the work on our own, without fear, without favor, and without outside influence from other co-equal branches of government. But I think justice is trending. I think we're moving in the right direction.
Seems like a perfect place to leave off. So Glenn, as always, thank you so much for taking the time. Appreciate it.
My pleasure, Brian.